Hello.
Okay. All right. So let's talk MRTC. So the goal here is we really want to make sure that we provide some background. It's probably been some time since you read the MRTCs, and because they are really the foundation of the agreement, and I think as our colleagues from ONC mentioned, they're really important big P public policy issues. And we're going to highlight public comments and considerations that we've been thinking about. And the whole idea here is not to try to say, oh, this is, in addition to ONC's public comment process, this is not a public comment process. This is really to help inform the development of the common agreement overall, because really the minimum required terms and conditions ONC develops and those that we're going to develop in conjunction with you all have to go hand in glove. So to give you a sense of the scope of what the terms were that were published in April, it covered a whole host of topics listed here, ever important definitions, a process around application onboarding, and then you can see the terms here around minimum necessary, transparency, and the like. What we're going to do is we're going to hone in on a handful of these where there did seem to be some pretty intensive public comments, and sometimes they were in support, and sometimes they were, thematic takeaways, and really just then pose there for you all to weigh in. The way we're going to do this, Steve, as an attorney, is going to summarize the contract terms. I'm going to do my best to summarize what we think we heard from the public comments, and then really open it up to you all. Same protocol as the others. If you have questions, comments, any insights you'd like to share, feel free to line up at the mics, and we will open it up for discussion. So Steve, I think exchange purposes has been a big topic of discussion all along the way. Do you want to kind of highlight what the MRTC's covered?
Yeah, I'm happy to. It's been a packed day, hasn't it? I feel like I should buy the first round. You've had to put up with me twice today. Yeah, applause. Okay, so we're assuming that you've read the MRTCs, so we're not going to read it to you. We're going to, what I'll be doing on the left-hand side of each slide will be a summary of the MRTC language in draft 2, and then on the right-hand side will be a select summary of the thematic aspects from the public comments. So, as you know, exchange purposes is defined in the MRTCs as the reasons for which an organization, be it a QHIN or a participant member, or even an individual for that matter, can use the interoperability available through the exchange framework under the common agreement to transact information. And so there's treatment, utilization review, quality assessment and improvement. I am reading this to you. Business plan development, public health, individual access services, and benefits determination. So a very robust set of exchange purposes. And I think that, saying that ONC anticipates that the common agreement is going to support very robust exchange. Now, like every, this goes by different names, but every network has something similar to this. You've all got something similar to this in your networks today. It's part of your foundational trust principles. And so, as we would expect, the MRTCs say, here's our list of exchange purposes, and this is the only thing you can use the common agreement for. You can request information, you can exchange information, you can retain information, you can aggregate, you can use it and disclose it for these purposes, and that's it. And then there's some additional language around, covered entities and business associates of covered entities, or a healthcare provider that might not be a covered entity, or a business associate. Probably not too many of those, but there could be some. And then, obviously, none of this is really relevant for individuals, because individuals can use their information and access their information for anything because it's their information. And so the definition recognizes the network concept and the limits on permitted exchanges, but also codifies that this is not meant to limit the ability of an individual to use exchange services available. So that's what the MRTC says. So Mariann, what about some of the public comments?
Well, the public comments, there was a sentiment of aligning with HIPAA, and particularly in the proposal, there were sort of a subset of certain purposes related to operations. So the idea there was we'll align it really, with HIPAA, particularly around TPO. There did seem to be agreement of having a more narrowed set of exchange purposes that QHINs would be required to support across the TEFCA ecosystem. And also the sense that, well, these could be a floor, a minimum set, but not, you can only, not instead of an exclusively set of purposes. So really allow, sort of a minimum set of expectations for purposes that have to be supported and then layer on top of that. And then there were other ideas similarly, you have core purposes. And this is, I know, the work that we've supported. It's been difficult to get networks and participants to support purposes beyond treatment. And so the idea is how much of a lift is it going to be to really have the community at large really agree to support other purposes like payment operations and even individual access and other purposes. And so is there a staging that you could do to sort of, acclimate to that? And then there was also some consideration about, really to what extent are QHINs responsible for exchange, supporting all exchange purposes? Does every participant have to support all exchange purposes? So what does that look like? So I think for us, and I'm going to pause and just make sure our ONC folks, did we get this right? I mean, is there anything you guys want to clarify? I'm going to ask you every single time. So, okay, it's our first foray, so I'm just checking in. So we have questions from you. I mean, were there, were there other additional comments that weren't reflected here that you felt were germane? And if, for instance, if the common agreement is fully aligned with HIPAA and TPO, what do you think about that phasing approach? What impact does that have? And should there be a baseline with the ability to expand purposes? And so I'll just pause there and see if there are any questions or thoughts on exchange purposes. You guys like the QHIN technical framework better than this? What?
Yeah, I know it's not quite as exciting, but
yeah, SAML assertions. Wow.
yeah, all right.
Jeez. Well, I know.
And much like, and I see, thank you, Stephen.
Feel sorry for us.
Much like, yeah, I did. Much like the QTF discussion, we'd like to make this conversational. It's hard with a group this size, but don't feel like you have to have a brilliant question or a brilliant or a scathing comment even.
Bring it on.
But just,
I mean,
stuff may hit you as we're talking, and we do want to, we're here to listen. And so, anyway, go ahead, Stephen. Yes.
Oh, there we go. So the original TEFCA did propose full TPO. The second iteration narrowed down O, mainly because folks felt that that was a bridge too far. To just clarify, the public comments on the next version were just do TPO. Is that accurate?
that's what we read.
Okay, so on the table currently, that will be discussed, I'm assuming in the work groups, is actually just doing TP&O plus the additional one, so benefits determination still and individual access?
Yes.
Okay. All right.
Well, just so we're clear.
It was some public comments. It's
Some
not
public,
universal.
some public comment.
Correct. Not everyone,
Right.
I'm assuming, felt that way. I guess
Right.
the question would be, since I did not this time around read all the public comments because I didn't have to. I didn't get paid to do that, so. Was it like an overwhelming response? I guess, is there like a way that we're leaning on that you can talk about, or is that private and can't be discussed yet?
No, I'm reluctant.
I see John's face that says, no, don't discuss that, so.
Yeah, I mean, obviously we respect that, but I'm always reluctant to characterize public comment process with things like overwhelming or underwhelming, or because it's so subjective, and what's overwhelming to me might not be overwhelming to you. So I think we're going to fastidiously avoid those types of adjectives on purpose, not because we don't have opinions, because of course we have opinions, but I think it's fair to say, and I'll let Mariann throw something at me when I say something wrong, that there were more than isolated comments about broadening the exchange purposes back to full TPO. But there were also more than isolated comments about, whoa, this may be too broad to begin with. So, yeah.
So just so I understand the process, so in TEF 2, as it was published, there was a slide and it had the exchange purposes that Genevieve articulated. And now this is the time where it's actually going to get decided what specific purposes are actually supported.
Well,
Right, based on the public comments that received, the written public comments, as well as what we hear in sessions like this and the listening session coming up.
So the idea is that taking that public input and other feedback, and it informs ONC's policy decisions that they make that would ultimately be translated into contract language and make its way into the common agreement.
But those are decisions that have yet to be made and are being informed at this very moment.
I think there's an ONC decision process around all of that.
and
Is that okay?
since the RCE, since Sequoia as the RCE is responsible to ONC to prepare the common agreement, in furtherance of that job, we're holding sessions like this to hear from as many people as we can to inform us in developing the common agreement. So.
Any other thoughts on that one? Yeah, you can take your time.
Yeah, sure. These lights are tough, man.
It's okay.
Just a question about care coordination and HIPAA. It usually gets, or at least I always get confused. It seems like it could arguably be part of treatment and operations. Is there any clarity on where care coordination lands in this?
Well, no, because I think it's really outside the scope. I mean, I agree with you that care coordination is often, and there's a huge debate, as you know. I mean, some people say it's operations, some people say it's treatment. Many of us think it's both. But that's really a HIPAA statutory issue and a regular, privacy rule issue. So I don't really know that the common agreement has the ability to provide clarity. I think the common agreement will align with HIPAA, and to the extent that something like that requires clarification, I think it would have to be done through the HIPAA process.
But expanding the purpose, the operational purposes would provide cover in either case, right?
Yeah,
Presumably.
yeah. I mean,
Okay.
right. In other words, if you have full O,
Yeah.
then yeah.
Yeah, do you have another question,
Yes.
Stephen? Okay, good.
Something that's come up a lot in my organization and which I've been thinking a lot about recently is exchange purpose versus purpose of use. So there's the reason for which you are seeking or receiving the information, and then there's the subsequent use that you might put that same information to after the fact, once you've got your mitts on it. Are we going to comment on purpose of use, and is that going to be tied to purpose for exchange?
That's slide 9. Future use is definitely one of our slides. Yeah. So,
Yeah, probably should have had that second, actually.
No, it's all right.
All right.
It's all right.
Anything else on that? Okay, we can always come back to any of these. So the next one where there was a good deal of commentary was the queue and application process. Do you want to touch base on this
Yeah.
one?
So the MRTCs, Section 2, has a number of subsections, as you can see, and extraordinarily detailed, contract provisions around how organizations apply to become a QHIN, how they are onboarded, how they're designated. You may remember there's a provisional status, and then then you pass through the provisional status once the organization is ready to meet all of their requirements. And so, and we didn't list it all here because it would be like 10 slides, right? But that's currently in the MRTC.
So this is an area, again, where there are a lot of comments, and the suggestion was, rather than having what are somewhat operational details, is actually put them in standard operating procedures, and there's precedent for that in other networks and frameworks like carry quality, and there were other considerations too. With a lot of I think, a lot of questions and clarifications required. And so I guess the question that we have for you all is, are there particular areas of onboarding that, of QHINs that would be of concern? And also recognizing that even if the details were in the common agreement, the RCE would still have to have an operational process to put that into effect, and there's a good deal of overlap there. So, would there be concerns about moving the onboarding requirements to standard operating procedures to provide more flexibility versus having them baked in the common agreement? So that's our question to you.
While you're moving to the mic, there was also some comments about the provisional QHIN and what does that mean and what are the criteria and the cohorting process. Some folks had concerns about, well, is that like a purgatory, or what exactly is that? So please go ahead.
So today, EHRs are required to be certified, and then they're listed in the chapel. Is there a similar kind of concept for accreditation or certification that you guys are thinking about for QHINs in terms of onboarding QHINs?
There is, we're certainly thinking about it, and this is an area we need to seek some input, but there would be criteria, and these were the criteria that actually were put in the MRTCs, but they would have to demonstrate that they have capacity and, meet the definition of what a QHIN would have to qualify for. We are going to actually be seeking input on what level of verification is necessary. So in current production networks, for instance, there's technical testing to verify that the ability to interoperate. Going above and beyond certification and accreditation, there's a level of burden one has to consider. And the question is, what assurances does the community itself desire? I don't believe there was any concept of accreditation or certification in the MRTCs themselves, right?
Yeah.
Right.
So I should have said this at the very outset. So, as a lawyer, it's second nature for me, but not for everyone. So as we talk about, go through these slides, my brain is very much in the place of this will eventually be a section of the common agreement. It will be contract language, and everyone that wants to be a QHIN will have to sign the contract. And so as we think about things like Section 2, if you think about it as, well, okay, if I have to sign this contract, how do I feel about this process? Do I want it in a standard operating procedure? Do I want it in the main agreement? Do I care? Maybe I don't care, and maybe there's a fourth option that isn't apparent to me at the moment. So as we go through the slides, I know it's late in the day, but I'd like to be thinking through, this isn't just this isn't a topical exercise. This will be in the common agreement, which everyone has to, all the QHINs have to sign. And then there will be flow downs that you as a QHIN will have to make to your customers. The framework calls them participants. And then some of them will have to be flowed down to their customers or folks, employees, et cetera. So I found that to be a helpful framework for me as I'm thinking about this. Is there any concern in the room about putting things in standard operating procedures as opposed to the main body of the agreement? And while you're thinking about that, we have a question or a comment.
I'm glad you knew I wasn't going to answer that one.
No, it's fine. Yeah.
The question that I had as you were talking about the flowing the terms down, this may be a really dumb question, so I apologize.
Not possible.
If a QHIN is going to have to flow down terms. If I want to participate in a QHIN, then I have to agree to those terms.
That's right.
But I also want access to EHI by agreeing to those terms. Are those terms then subject to RAND and everything else that's in the proposed rules too? So like do the CCA term, or does it all have to be subject to RAND and reasonable cost and all that? So how does that all?
That's a different framework, actually.
Yeah, so I would separate, the RAND framework is really around, and it's a good question because these things do sort of cross wires. There are maybe when we go through, we can talk about where there are flow down expectations.
yeah,
So the RAND
yeah.
concept is really around information blocking.
Yeah.
There are terms in the proposed MRTCs around fees, and maybe we could touch base on some of those.
Yeah, that's, thank you.
Well,
That's great.
let's move along, because minimum necessary may be a good example. Did you have, hold on, Leslie.
I just had a question. So are you suggesting that the standard operating procedure approach would then provide leniency towards technology specifications in such that there would be an evolutionary aspect to the technical specifications by adopting standard operating procedures rather than prescriptive technical specifications?
No, I mean, the tech specs really are the domain of the QTF, which, Dave talked about in the previous session, and those are part of the common agreement. They're incorporated by reference, but it's actually not a bad example because the QTF will be a distinct, it will be incorporated by reference. It's part of the agreement. But what we're talking about here is an application process. An organization that wants to be designated as a QHIN, what's the form of the application? How long do they, what do they have to submit in order to apply? Do they have to submit everything on day one, or can they submit stuff, within a week or 10 days or 14 days or 30 days? What's the turnaround time for the RCE to review that? That's what we're talking about here.
It's more operational.
Operational detail.
Yeah. Paul?
So I would absolutely support putting it into the operating procedures and moving it out of contract language.
Yes, thank you.
Okay, thanks, Paul.
All right. Matt?
Matt?
Yes.
Yes.
And our experience with the e-health exchange just makes it clear that that's much more efficient and actually gives the appropriate content to the appropriate role. So,
Right.
absolutely.
Okay, good, thank you. Okay, minimum necessary.
Yes, everybody's favorite. Minimum necessary is a HIPAA term. You all know that. And as you also know, treatment, it doesn't apply to treatment. But for every other, use or disclosure, because that's what HIPAA regulates, or uses and disclosures. For every other use and disclosure, an organization, a HIPAA-covered entity, or a business associate is required to only disclose, and really disclosure, only disclose the minimum information necessary in order to meet the purpose of the disclosure. All right, I'm sorry to be so convoluted in my talking, but so if someone asks you for information, then before you respond, you have to have a process in place to say, am I over disclosing? And so that's for everything other than treatment. So the MRTCs, and you see the section references here, and just for orientation purposes, so 2.2 is somewhat of a general section. Section 7 is really a parallel for participants. So section 3 talks about QHINs. Section 7 talks about participants. Section 8 talks about participant members. And that's why you're saying, why is this referenced so many times? The MRTCs as currently drafted have 3 parallel sections, one for QHINs, one for participants, one for participant members. And there were public comments about that. We didn't put it on the slide, but I don't want you to be confused. And so, the MRTCs adopt the minimum necessary requirements contained in HIPAA. And they say that the QHIN, when it's requesting information, when it's using information, when it's disclosing, information, EHI, that it has to align with HIPAA, as well as the MRTC respects the HIPAA carve out for minimum necessary for treatment, as I talked about, but also for disclosures to an individual. It doesn't apply there. For an authorization-based disclosure, think about the SSA use case, for example, when you sign an authorization, or life insurance, when you sign an authorization for your own information, or where required by law. So it really maps to HIPAA there. And then, as the second bullet says, the same obligation for participants and participant members. And so, let me stop, and you can talk about the public comment.
Well, yeah, and it also would levels the playing field regardless if you're subject to HIPAA or not. If you're not a covered entity or covered by HIPAA, you would have to comply. I mean, basically it was agreement. It seemed to make sense.
Yeah.
I think the question was, well, to what degree are you obligated to make that determination? If you're a recipient of a query, I mean, are you supposed to assert whether or not that request was subject to minimum necessary? Should the QHIN be in a position to monitor minimum necessary? And we're thinking that sort of puts some policing in effect that doesn't really occur today. And if there are any strong feelings about that, we're happy to hear it. We're also happy to move on. Does anyone have any thoughts on that?
Yeah, Bill.
I guess one question is, you know, with all the activity around like a fire bulk download, and I know maybe we're getting off onto fire here, but it seems to go against this minimum necessary concept, and I'm just trying to understand how those would play out together.
I don't know. I mean, you know, that's a great question. You know, again, we have to remember that you know, the HIPAA, that the privacy rule was now, what, 18, 19 years old? Security rule a little bit younger. And so I think that's a very important question to be asking. How does minimum necessary apply? We don't have time, and you're thankful that we don't have time for me to go into a, you know, historical dialogue of the minimum necessary rule. But it has served a very important purpose. I've also seen it, you know, become a barrier. So with fire, I don't know. It's a great question.
All right, let's move along. Meaningful choice. This one was interesting, and I think, yes, I'm sorry.
I'm so sorry, yeah.
Oh, sorry,
No,
Seth.
don't apologize.
Sure,
We're just having a
so-
hard time seeing people in the lights.
Yeah, thanks. I guess it occurs to me on that last one, if HIPAA already has sort of the auspices to make the determination of permitted purpose, what's the value add of then nesting those same terms here, and then, as you're saying, putting an enforcement point in? It seems, unless I might be misunderstanding it, but it seems sort of redundant if we're all sort of playing by a set of rules as it stands, and then to sort of take that rules which lives someplace and then duplicate it in another spot.
Well, there are a couple things to consider, and that's a good question, is that the scope of TEFCA could cover PHI, but it also could cover information that's not protected by the rules. So it could be, it's really any electronic health information. So if for minimum necessary, if HIPAA is sort of the contractual standard of performance, then that sort of levels the playing field for all information that is exchanged under the TEFRA construct, and it also bridges the gap of non-covered entities or non-HIPAA entities. So I think that was the whole idea. The whole secondary question of, well, you know, how far do you go, and having assurance of that. Well, today it's addressed like in the carrier quality agreement, it's just a part of the terms. And if there's a violation, then there are consequences. So, yeah, that makes sense.
Yeah, that's a really important point. You know, this, as we said this morning, this is broader than PHI. This is EHI. And so automatically you're beyond HIPAA because you have a broader construct. And then for the non-covered entities, this would be a contract term. So.
This is totally out there. Sorry about that. I think it's related, but I may not be. This,
Sorry.
to connect to the Pulse conversation we had earlier, under HIPAA, for emergency and life-threatening, you can send data. So I had this weird feeling when Steve was putting up the umbrella, why don't we have Pulse next to it? Should we be thinking about that here? Should we be explicit to say that if there is all QHINs support emergency services at a national level, we have a tool to do that? Just a thought, coming back to what we were talking about earlier, because that's really where we need to get to. So I throw that out there. If it's crazy, it's crazy.
It's actually not crazy. On the Pulse context, we did think about that, and that's really a treatment use case. It's just a non-covered entity treatment. But EMS is more broadly. It does. It does. Yeah, we should definitely look into that, Matt.
Yeah, that's a great point. Okay. Oh.
Hi. A point that's kind of interesting with the way comprehensive federal legislation is being crafted is that there would be a carve-out for covered entities. It wouldn't necessarily apply to business associates, and I don't know what QANs would be.
It could be any of the above.
And so now you're starting to look at what comprehensive federal legislation, privacy legislation might look like and how it will impact your QANs, and so I think you need to start thinking about that.
Agreed.
Excellent point.
Excellent
Yeah,
point.
thank you.
Meaningful choice is an interesting one, and I think if we could just do a quick synopsis, this is one I think there might be comments on. Yeah.
This is a huge issue today. So the MRTCs require a QHIN to respect an individual exercise of meaningful choice, and opt in, opt out, whatever that may be, unless that exercise of meaningful choice is overridden by applicable law. And that could happen in some cases. But otherwise, I think the MRTCs really elevate the legal significance of individual choice, and an individual's exercise of their meaningful choice. Now, but then the MRTC also says, look, we understand that people will sometimes change their mind. They'll opt in and then they'll decide to opt out, or which is the problematic one sometimes. And so the MRTC says, if there is no exercise of choice, or if someone opts in and then later changes their mind, it's okay for information to have been exchanged, access used, disclosed, prior to the individual opting out. So there's no retroactivity to that opt-out. And it would be prospective, but not retroactive. And then also the MRTC imposes upon the QHIN the obligation to have a process in place to be aware of the meaningful choice, to respect the meaningful choice, to incorporate that into the data flow, and that's really, this is all tied to situations in which an individual has made their meaningful choice known. Okay, you don't have to telepathically intuit that, but the point is, and I think it's very important, is that the MRTCs, I think, are putting an exclamation point on meaningful choice, and saying to the industry, hey, this is important. And of course, there's the 5 business day. It's very granular. I'd love the comments on that if anyone has any. That within 5 business days of an individual exercising their meaningful choice, the QHIN, or maybe the participant, or maybe the participant member, has to act on that. So basically a business week. And the last bullet is, so to your point, this is a flow down. This is one that the QHIN must flow down in its agreements to its participant, and then that participant must flow down to the participant members.
So naturally, this was an area that there were a lot of comments, and actually there were a number of concerns about this, the MRTC that was proposed. Most notably, there was mention that HIPAA already addresses a basis for supporting meaningful choice. There was, and by lacking, if you don't align with HIPAA and include things like carve out for TPO, et cetera, or that could be issues with having to revise existing HIN agreements, that since this would be a different standard in some instances. And then also, if you require providers to support this, something that goes above and beyond HIPAA could create a dual track for their health information practices. So, the question we really had was, would there be concerns if the language basically around choice just pointed to existing laws and HIPAA in light of the concerns raised? And then we have another question around that.
So when you talk about HIPAA, you're assuming that all points are covered entities or covered under HIPAA, right? Which is not the case when you start having.
Actually, I think that there isn't there not a basis in the other MRTCs that you have to comply with HIPAA
Yeah.
across the board. Was that it?
Your previous comment said if we refer to the existing law as an answer to that, then the existing law is only concerns covered entities. So just make sure that we are more umbrella approach to that.
Right.
And then secondly, be very cautious, because when confusion exists, the only answer is no. And that answer is given to patients. No. I'm sorry, you can't have that according to HIPAA. Oh, Do you know how many times that's answered? So the more confusion you have, the more burden becomes on the providers to declutter it, but the answer is no to patients. So we cannot give more reasons to refuse access and more smoke and mirrors to refuse access. Harmonize it, provide clarity, and make sure that it's in the eyes of a patient and not in the protectionist eyes of the provider for the patient's data. Thanks.
Thank you.
Thank you.
I think the premise here would be that it would be, if there is pointing to HIPAA, that it would apply universally to all QHINs irrespective of their covered status, right?
No, that's exactly right, and that,
Okay.
we may have glossed over that.
I think
but
we totally did.
when we talk about adopting HIPAA for purposes of the common agreement, and I'm sorry if I create confusion, we're talking about it being a contract term. So if you sign the contract, if you sign the common agreement, then you're bound by that standard, whether you're a covered entity or not, or a business associate or not.
I think that's what the commenters were suggesting.
That's what the commenters are and well, I think that's what the MRTC says as well. So I think that's consistent with the MRTC. Anyway, Michael.
So this raises another intersection point between the information blocking and the MRTC. Specifically, I'm thinking of the example that's used that a health system requiring consent for treatment would constitute information blocking unless that was required by existing or state law. So I guess there's a specific question around that, but more generally, given the status of the information blocking rule, what processes are going to be taken so that these issues, once the final rule is published, then there won't be mystery around all that. There'll be specifics. So what happens then with the MRTCs?
I think that's you.
Well, I mean, I think once the common agreement is final, that the terms will be there won't be any mystery. I mean, the terms will be the terms.
How does it overlay to info blocking? Applicable law, right?
Yeah. Mariann just said applicable law, but yes, I mean, so my view is that information blocking is on its own track. We anticipate a final rule. I think Dr. Rucker said end of the year, but we anticipate a final rule when we have a final rule. At that point, that becomes, I mean, first of all, information blocking is already federal law, as I said, and has been for 3 years. The final rule will provide important detail about how that will be operationalized. And so the common agreement will have to obviously, work within that framework, just like it does HIPAA, just like it does any other federal law. Yeah.
Genevieve?
So I'm going to make a plea not to just roll back the meaningful choice concept to the existing law. The reason being, we're talking about exchange on a level that we don't have today when this is actually at scale. And we are in an era where individuals are increasingly concerned about their data being shared for very valid reasons. And the idea behind this meaningful choice is giving them enough say that they feel comfortable with the data that's being shared, so that there's transparency to it, so that we don't have a wide-scale patient suddenly revolting and being like, I don't want to be a part of this at all. A little bit of transparency and a little bit of optionality goes a long way in helping people feel comfortable with sharing their data at this level. And I think it's really, really important that we don't set that aside in order to do what is easiest for us technologically, because we don't want to spend the money and we don't want to put the time into building out the standards that allow us to do this. I'm just sort of a little bit tired of hearing we can't feasibly do this when no one's doing it because they're not required to do it, and therefore the technology never gets built. So I would just make a plea for keeping it in there in some respect, so that patients have a little bit of say over where their data is being exchanged when we're at this scale.
Thank you.
I just wanted to make one comment related to public health and just remind folks that there are state laws that require, the sharing of data for public health purposes. So when the QHIN gets the query asking for information and a patient has opted to exercise their right to meaningful choice, if that query's come from public health for valid public health reasons that complies with state laws, then you're going to have to answer that question and respond to that query, even though the patient has exercised this meaningful choice. So it's very complicated. And I just wanted to make sure folks keep the public health and state laws in mind.
Thank you.
Laura.
Good point.
Hi. I guess this is just an operational kind of consideration, which is really around this idea that we're going to need to notify all of the other QHINs when we actually receive a patient opting out, not wanting to participate in the health information exchange. And I would suggest, I've seen this happen in other states that we work in, and I would suggest that it might be a role for the RCE to actually manage that process themselves, so that we actually provide the information to the RCE. The RCE then is responsible for disseminating it out to the other QHINs that the patient has made a choice to opt out. And so I would just ask you to give that some consideration, because some sort of centralized way to manage that for us is going to be really valuable. If I have to reach out to the other 32 QHINs every single time I've got a patient that's opted out of one of my exchanges, it's going to be pretty problematic. So just a suggestion.
And how do you reconcile that?
Yeah, that's a good point.
Yeah,
Thank you.
Thank you.
Yes.
I'm not sure who was
Oh,
there
yeah.
first.
So, quick question, somewhat related, a little tangential, but the 42 CFR Part 2 sharing of information is still a thorn in exchange. Did that get factored into any of this at all, or is that still separate because it's a separate federal law?
I can't speak to what ONC considered. John, did you want to address that at all? It wasn't carved out in the MRTCs. Sorry. And then you can correct everything else we said wrong.
No, you guys are doing a great job, and I will just say that applicable law applies, so
Yeah.
that's going to, inhibit folks from being able to exchange using that. ONC doesn't own the 42 CFR Part 2 regulation, so can't really comment, deeply on that. So, yeah.
Okay, thank you, John.
I heard Dr. Rucker speak about the Facebook penalty this morning. And I'm just going to pose the question for all of our current or previous Facebook participants, if you were offered meaningful choice of how your data was shared by Facebook. And so when you're thinking about the term meaningful choice, why don't we just ask patients what they choose to share and create a logical, technical solution to implement that?
Thank you.
Thank you.
I believe you were waiting.
So in my mind, the whole point of interoperability is so that no matter where you go, people have your medical record, they have the complete picture of what's going on. So I would actually be very, apprehensive about giving patients too much of a choice, and with granularity, like you have 10 medications, which ones do you want to share with this organization versus this organization? I see that being really confusing. I see it also being really confusing for providers. Right now in our system, we give providers the choice of sharing things with patients on their portal, certain things, and they struggle over something with just notes. So when you're starting to look at all these different aspects in the patient medical record and what you're going to share with whom, I think that that's going to be super confusing. And then as our EHRs are beginning to reconcile that data into their own medical record, then sharing that to somebody else gets really confusing too. And you have different medical records depending on where you go, and that's a big concern for me personally, so.
So the concept of meaningful choice doesn't exist. It's like a whole new nomenclature. And when you look at HIPAA, you've got not just the right of access, it's the right to object, it's the right to amend, it's the right to put restrictions, all these things. But all of that is falling back to the broader fair information privacy or practice principles, which is, and this whole concept is around rights of individual participation. So one thought is just to consider how you might name this. It may be around that very well established and endorsed individual participation, and then ask which levers are appropriate for a QIN and for the RCE. If you're a conduit and you're not storing it, and maybe you're a service provider, the levers, the kind of rights should be appropriate to the role that the QHINs are playing. It's a really complicated set of issues, but I was just trying to offer those as some concepts. And then the other thing, I think consistent with others, is we talk about being a single on-ramp. We should be a single on-ramp for individual rights.
Interesting, thank you.
Thanks.
Ann, did you want to go?
Yeah, I just kind of want to reiterate to some extent what Genevieve said earlier. We tend to get into this very patriarchal view of patients, the healthcare community in general, in that, our goal is to make the patient as healthy as possible. Well, as a patient, I have the right to decide I don't want to be as healthy as possible. And when it comes to sharing information, particularly when we're talking about EHI, not just PHI, we're getting into a situation where customer expectations are changing so rapidly. If we point too closely to HIPAA, I'm thinking of, Facebook was mentioned earlier, but the Google Ascension project. And that all went, nuts, and Google said, hey guys, we're following HIPAA. I have no doubt that they are, but that doesn't mean that customers understand that that can be done under HIPAA. And so there has to be some balance between things that we can implement now, sort of what Dave was talking about, meeting the industry where it is now, and trusting the patient to make these decisions. If a patient wants to say, you can share information with my PHR, but you can't share it with anybody else, they should be able to do that.
Hans, sorry I overlooked you earlier.
That's okay. Question that I have, building on some of the comments that Genevieve made and others, and looking at the balance between what would we like to achieve in meaningful choice, as well as related consent management, to be able to get to that at a scalable national level, but we like to achieve that. At the same point in time, the feasibility that concerns have been raised of what are all the steps, the standards, everything else that need to be in place to actually make that happen. In those kind of situations, how is the RCE and the process thinking about progressing something like that, where if we were to put something in the MRTCs in version 1, we might be facing a very challenging effort to get that in the day that is in place. Yet at the same point in time, if we don't put something in, then it might take forever to get there, the usual balance. What is the general approach to tackle these kind of very difficult issues that have great objectives, but the feasibility is not quite there yet and requires effort and focus and incentive to help us get there? How are you thinking about that to tackle that, so we don't get in a situation where if we don't have it in, everybody will forget about it?
Well, there are a couple points there. One is there were some concerns if you raise the bar too high for QHINs above and beyond what is current obligations, it creates a disincentive for anyone to participate at all. I'm not saying that that's the issue people would, object to, maybe not. This is where, and I wouldn't say that the RCE has a particular approach and idea in mind. Practically speaking, we have experience doing stuff like this. You have a provisional use case, you'd pilot test it. This concept of incrementalism is going to be absolutely imperative to develop this 21st century next generation network of networks. That's the only way it's going to work. And so all these are great ideas and great feedback, but we're just going to have to be very thoughtful about what's practical, and I think that's kind of the best way. Now, there are a couple mechanisms we've used through, like again, pilots and use
Yeah.
cases and
Yeah.
provisional requirements that then go through ratification, and it would probably be the easiest way to, if we really want to do something that's markedly new.
Maybe as a follow-up comment there, is this another place where between the MRTCs or the Common Agreement in general and the QTF has an opportunity to build the glide path in the
Yes.
QTF
Yes.
and have the basics in place?
You could
but-
actually have the policy very general in the agreement and have ARTCs and the QTF as companion materials that are much easier to change. Absolutely.
Yep.
Yeah.
So I'd like to offer support of the meaningful choice. It's very important for patients to be able to make these kinds of choices, and the argument that it confuses providers is not a valid argument to restrict our rights of access and our rights to have prohibited access. I would like to note the work that ONC did early on with the model privacy notice, which we attempted to get into very granular consents that indicated things like temporal use, access to certain types of information, where the data was stored, the use cases around them. And I would encourage, I know work is being done in ONC to advance that along with Karen Alliance and along with Sequoia and others. But the answer to, gee, that's tough, should never be at the expense of the patient.
Yeah. Thank you, Leslie.
You're right.
All right, Alan.
Wow, we've
So my
woken everybody
concern-
up now.
I told you, we should have skipped the other ones and gone straight to this. I told you. They're not going to care about
So
no
my
one
concern with meaningful choice, and I agree with what others have said about the importance of patients understanding where their information is going and things, but my concern with it is when HIPAA was created, we lived in a world of records were on paper, right? If I went to my provider's office, my records were on paper in that office. And so anywhere else I went was a release of information, whether it was the specialist across the street or the hospital across town or two states over. Anything outside of that physical building was a release of information that required something to be mailed or faxed or whatever. Now we live in a world where I live in an area that has a whole bunch of Epic customers. And I go to one, and if I were to go to any of their facilities across 3 different states, there's no release of information happening, right? I can go to any of their clinics, any of their hospitals, any of their urgent cares, and there's no release of information. It's one database that everyone has access to. Yet if I go to my PCP's office, which shares a parking lot with a Vancouver clinic, I go to Legacy, and there's a Vancouver clinic, and there's a Kaiser right across the street, suddenly those two, even though they're right next to each other, are releases of information. How does that make sense when I can drive 4 hours away and it's not a release of information because they're on one database? So when we talk about this idea of meaningful choice, what does that actually mean when, depending on the size of the database, it may or may not even be a release of information across the street versus 10 states away?
It's also maybe a question of intra-network versus inter-network.
Well, it's a great point. We could talk about it for hours, but just, you know, all of this is grounded within the law we have today, right? So that's true always. So HIPAA regulates not just the release of information, which it calls a disclosure. It also regulates the use of information. So even today, within your example, HIPAA still is relevant to how your information is used across those 4 states. But it's a very fair point, and I think highlights the fact that, you know, the privacy rule's 19 years old, and things are a lot different than they were in 2001, in 2000.
Stephen.
Regarding meaningful choice, I also don't think provider confusion is a reason to limit that functionality. I think providers, speaking as a provider, providers are well aware that they always are functioning with incomplete data, whether the patient is choosing to tell you a piece of their history or you can't get a piece of data from your local or another system. So that's well known. But I think that if we build a system around meaningful choice, it has to have 2 very specific functionalities. One is that the patient, when they're making the choice, has to be adequately informed of the potential impacts of their choice. We do this when patients, you know, want to opt out of information sharing, and I've worked with our privacy partners, and they go through an informed consent process so that they understand that you could die because of this choice you're making. And I think that's very important that that's made clear. The other is that as a clinician, I just have to know that there's missing data. You got 10 meds, and there's 2 that you didn't get. So long as the patient is conscious, I can have a compassionate conversation with them and say, well, I see that we've limited the data here, let's talk about that. If they're unconscious, that's what you explain to them when they made their informed consent decision. But I mean, I think so long as we include patient informing and provider informing, we could evolve to manage this.
Thanks.
Thank you. And this is exactly the kind of dialogue we want to have. And just to be clear, the RCE is not making any decision on any of this. We are here to facilitate a dialogue and uncover all the different perspectives so it can inform the policy. And there are a lot of ways, I mean, just sitting here thinking about, you know, there are a lot of ways in which this could be supported or piloted or, you know, so there are lots of options.
So we're running out of time.
I think there's one more issue. Do you think we should run? That's what I was thinking.
Yeah.
I think we have to talk about this issue.
We do.
And we might just table the ARTCs because I feel like we have time on those.
Well, let's talk about those and see where we are.
Okay.
How about
Fine. All right, whatever. It's a negotiation.
Always.
All right. Go for it.
All right, so, and there was a specific question early on about this future use. So the MRTCs specifically address this and say that a QHIN, a recipient QHIN, a QHIN that receives EHI, is permitted to further exchange that or hold on to it, you know, retain it, aggregate it, use and disclose that EHI only in accordance with applicable law, which is always, you know, in place, and only for and then we have the sub-bullets, all right? One or more of the exchange purposes in the common agreement, that recipient QHIN's proper management and administration of its business and legal responsibilities under the common agreement or the BAA, not in general, but under the common agreement or the BAA. Investigation of a breach is defined in the common agreement in order to comply with either HIPAA or other applicable federal or state law. Judicial administrative proceedings, subpoenas, other court orders, or for law enforcement or governmental authorities. You understand what that means. As otherwise permitted by applicable law, and that's a bit of a catch-all. And then, last but not least, where further exchange, use, disclosure, aggregation, retention is specifically approved by the individual after the individual has received notice and makes a knowing consent. So that is that is, you know, that's what the MRTC says. Then of course there's a carve out for information that a QHIN or someone else would obtain for individual access services. So in other words, if I as a QHIN have a relationship with an individual and I obtain that information pursuant to that, to providing a service to that individual, then my ability to retain, use, aggregate, disclose, exchange, it's much narrower. It's clamped down to where, and those are my adjectives, what the MRTC says. It's restricted to only uses consistent with my provision of those services. And then all of this is subject to audit. So that's what the MRTC says about permitted use and future use. Mariann?
Well, there are a lot of comments about this one.
There were.
Not surprisingly. And I think they're really wanting clarification about how this would actually work, and then just sort of, there was a suggestion by some to align this with, you know, information blocking HIPAA and other laws. But then there were others who raised questions, and I think this is really compelling. I'm interested in hearing from you all. What are there unintended consequences or implications if the future use of the information is restricted so much. So under existing frameworks, I think it just points to applicable law, that once someone receives information, they rely on it, it's, maybe if it's for treatment purposes, it's written into the record, and once it's in the system of record, then it's really governed by applicable law. There's not sort of this tagging and forever, future protections of it. So I'll pause there and just see what you all are thinking about this. I mean, just, truly. I was waiting because this is your issue.
Yeah, it's an issue.
Waiting all day.
Yeah, this is an issue that's important to my organization.
Yes.
And that is this concern that data exchanged for one purpose can be used for any other permitted purpose. Because, and this has come up specifically in the area of sharing with payers, that we share data with payers for ostensibly treatment purposes, whether it's called treatment or operations, is a HIPAA thing, but, for care coordination, for care management, for prior auth. And then there's concern, and I think reasonable concern, that same data can be repurposed and used for making payment decisions or contracting decisions or, other kinds of business decisions that could harm the provider that shared the data and or the patient about who actually owns the data. And I think that this is a key moment in history, where we get to make this decision. Once that data is out of the bag, can it be used for any purpose? And if so, how do we make that really clear to provider organizations and to patients?
Thank you, Stephen.
Thanks, Stephen.
Bill.
Quick question about the kind of where you're talking about. Is it at the QHIN level, the individual level? Is it at the member level? And I think, the answer to some of this stuff depends on which level we're talking about. Like if you're a QHIN and you're broadcasting out patient discovery queries to 30 other QHINs, can the QHIN persist that query for future use, or is it really intended just to be a conduit in the HIPAA definition?
Well, this is at the QHIN level, so it's in section 2. And then
this wasn't a flow down?
It's a flow down.
Was it a flow down
Yeah.
for ONC? Okay, it was a flow down
It
to
was?
the
All right.
participant, and we just didn't have the reference.
Thanks, Genevieve.
I'm just repeating what John just nodded to, I swear.
All right, so there we go.
All right,
Flow
yes,
down,
it is a flow down.
which one would expect.
Yeah.
But to your point about, we answered your question.
I think it was Genevieve.
Yeah. So I think Stephen's point is fair, and I'm going to walk through the logical reasoning on this. There are clauses around data reciprocity requirements that say, for that set of exchange purposes that are approved, if someone asks you for that data for that exchange purpose, you have to give that data for that exchange purpose. So on reusing the data for any of the exchange and it's not anything, it's limited to the approved exchange purposes or applicable law, which covers you, like if law enforcement comes and asks questions, right? It makes no logical sense if you've all agreed that you're exchanging data for those 7 purposes, it's 7, whatever number we're at, 8, and I have to give it to you because I'm required to. If I'm going to make you come back and make the request again to reuse it for one of those same exchange purposes that we've already agreed to and I'm already required to share that data for. But it's limited to the exchange purposes that we've agreed to. So if payment isn't one of the final purposes, they can't just reuse the data for a payment purpose, right? Like that would be a misuse of the data. The one thing I do think we need to think through in that, and this is a super fair question, is minimum requirements or minimum necessary requirements are different across different exchange purposes. So for like it doesn't apply to treatment, but it applies to the other ones. And so I do think we might need to think through on the data reuse, how you ensure that minimum necessary is followed. If my original request was for treatment, so I got everything, I probably shouldn't be using everything for a prior auth exchange purpose, right? So I do think we probably need to think through how you provide those set of protections. But I think otherwise, because the data reciprocity requirement is in there, you already have to share it anyway, so why hit the bandwidth of the network to ask for it again? If those data reciprocity requirements come out, which hopefully they don't, then I think it's a very different conversation that you have at that point.
Great point. Thank you.
It also assumes that the data value is a stagnant value, and that doesn't apply in genomics. So my data today that I provide, either my tissue or the results of the use of that tissue in sequencing. Today, the computing power used to indicate findings from that data has a value of X. Well, in 20 years, that data might be able to be recomputed in a new way that has a value of Y. And so as we think about these criteria, we should also take into account future use cases like genomics for data repurposing or any type of data that is gathered at the point of care that will have new value. I think the argument about the and Google issue was not about whether the acquisition was legal and use of that data was legal, but the actual commercial value generated as a result of that new use case was way beyond treatment, payment, and operations, but in algorithmic creation. So we have to think about data as an evolutionary value proposition, and therefore the protection of that data for the patient and the minimum use and repurposing needs to be thought of in that context. Does that make sense?
Yes, it does. Thank you.
That's really
so much.
interesting. Yeah, thanks. I'm not sure who was next.
Ladies first.
We just keep pointing at each other. So I think that was very well said, and I don't want to repeat the same things. I think about the secondary uses that were pointed out for payers to use provider information in a secondary way that might be advantageous to the payer. And I also think that we need to think about how individuals' data is being used for secondary use by the providers and sometimes the payers for additional purposes as well. So many health systems are using our de-identified data right now and profiting on that for research without our permission. Why not give us permission to have a voice in how our IP, our individual IP, my data, is my intellectual property, is used? And I do agree that the segmentation is a huge problem, and so that's why I try to talk about logical solutions that are reasonable for across a society. And you can't care for someone and like segment out medications that could impact them and their health. We know that. So I'm just trying to think about it in ways that if it is a secondary use and there is a monetary value, why not let the individual share in that value as well?
So one of the things, and I agree with everyone's comments here, personally, recently at our organization, we have a shift to value and risk arrangements and stuff, and we're working with payers and taking in their claims files and loading it into our system to close care gaps so we can do shared savings and stuff, right? And a recent example, and I think this is kind of alluding to what you were talking about earlier, Stephen, is, we're bringing in, we have lives that we're responsible for, and we have members that we're loading in these claims files for, and it has their data in our system. And we had an employee who didn't have insurance from the hospital, but had insurance through her husband's company, which fell under our responsible lives. And the patient ended up coming to one of our facilities for care and was asked, "Oh, I see you had an ortho visit and so, and was like, "Well, how did you get this information?" When they did not, we changed our consent model to opt out, but I think provider organizations have to take into consideration that if they're loading in these claims files, that do the patients really know that we're doing that, right? And so she decided, I'm going to opt out. So yeah, you opted out of the HIE, but then we had to go back to our legal and privacy team to say, well, does this really constitute an HIE-related event that we loaded in the claims file? And we really had to go back in and redact all of those claim files for that patient. So I think that's something that we all need to take into consideration, not just the HIEs, but the data that we're loading into the system. And this was a recent example, and I'm pretty sure I think there's a lot of EPIC organizations here that are represented, and a lot of people are planning on doing the same thing, but it's something to take into consideration.
Wow, thank you very much.
That's very interesting, thank you.
So what he said. And again, I think we want to go back to fair information practices, which are one of the foundational principles is consent, and HIPAA addresses that through the notice of privacy practices. A question comes up about whether you expand the permitted uses for exchange and whether or not they are now going counter to those notice of privacy practices. So I think this might also tie back into Carol's comment about being logical. So you actually have to look at the whole flow from a consumer's perspective in the context of recognized fair information practices.
Good, thanks.
Thank you so much. I know we only have a few more minutes. 6 minutes.
6 minutes.
You
Excuse
really
me?
want to cover those additional terms and conditions? Or
Can I ask something?
Yes.
I know you can't see me because of lights and everything else.
Sorry.
That's all right. I'm Neil Holt. I'm with Arkansas Share,
Hi
the
there.
state's HIE through the Department of Health. This kind of reminds me of my meeting in Reno in 1997 with a bunch of people trying to figure out this thing called HIPAA. But anyway, nobody's really addressed the audit side of this, because a patient can request where their medical record is gone. So if the QHINs retain the information and they go to the doctor's office, then the doctor office notifies the HIE, we're able to do that, but then wait a minute, we have no idea where it went out in outer space. And so then you gotta, who do we notify? Because a QHIN could spread that because somebody in Oregon could figure out something from Arkansas, and it may go to multiple QHINs before it reaches, and if every QHIN retains the patient's information, then how are you gonna do the audit on that?
I'm really glad you asked that. And because Mariann and I were just talking, there are, ONC did an amazing job of drafting a very comprehensive set of MRTCs. And we've only today had time to talk about a few of them. And actually, we're only going to end up talking about half of what we had slides for, which is fine. That's fine. But
I told you wouldn't have time.
But I know you did, and I just, as usual, I didn't listen. But to your point, sir, there are actually MRTCs that talk about summary of disclosures and require QHINs to provide summaries of disclosures. And so even though we didn't talk about it today, it is in the MRTCs, and there were comments about those in terms of clarification and various things. But I'm really glad you brought that up. I don't want anyone to think that ONC didn't address it, because they absolutely did.
Well, I think that, I'm sorry that we're not going to get to
Oh, it's okay.
ARTCs.
It's fine. I mean, this is, so we had a whole nother slide deck on the ARTCs to sort of socialize those. But we'll also do those in another session.
We will, and I'm wondering if we need an all-day meeting.
I think we do. And we would love your feedback, and not right this second because we know you're anxious. Be careful what you ask for, right? We know you're anxious to get to the bar or Uber or dinner or Metro or whatever. No, we'd love your feedback on how did you find this session valuable? And if you didn't, it's fine. We'll be okay. Thank you, Stephen. I know. I wish we had little polling things, right? No, we really are taking seriously our obligation to ONC to come up with a common agreement that folks are going to be willing to sign. That's our job.
And that it's thoughtfully written and takes into account the perspectives of consumers and engenders public trust.
Exactly.
And all those things.
No, exactly. No, I mean, we live and breathe this stuff, so this is really important to us. And so, this type of feedback is amazing. But we want to do this in a way that's valuable to you all, and when I say you all, not just the people in this room, but everyone else. And so we'd love suggestions on how to do that. We would love your feedback on this type of in-person setting, which we can't always do, and other things.
Exactly. So I think this is the moment where I thank you all for coming to our very first RCE session, and just thank you for your just willingness to spend your time with us and just being so engaged. It's helpful immeasurably, and we will certainly be open eyes, open ears for any other feedback you have. So thank you all for joining us, and safe travels home.
Yeah.
Thank you all.